Now, you're all very welcome to this very special occasion, at the Law Conference in honour of Professor Fergus Kelly. Fergus has been, since he began as a scholar in the Institute, he's spent his career in the School of Celtic Studies, and he's published widely on all aspects of early Irish language, literature. Outside early Irish law, we could mention particularly the two poems on the Columcille poems in Area 24 and 26, which are extremely important for any account of the development of early Irish metrics. But of course, it's in the field of early Irish law that he is best known, and it is to celebrate this aspect of his work that we are gathered here today. And perhaps, of course, you will get on the leaflet there illustrations of the books, Fergus's books, and of course this is probably the best known one of all, which has been first published in 1988, and this marked a revolution in the study of early Irish law. It is the first, and I mean absolutely the first, reliable account that you could give to anybody, an undergraduate, a specialist of early Irish law. And it's been reprinted many times, 5 times, and the last time in 2009 with a revised bibliography. Right. Okay, so there's no need to mention, I suppose, that all of the speakers here, their area of endeavour, it's law. And our first speaker, of course, is very well known, needs no introduction, in the area of early Irish law, and of course he edited in the first volume published in the Early Irish Law series, which again was a great innovation, the edition of Bretha, the B judgments, which he did together with Fergus Kelly. So it's my great pleasure to introduce to you today Professor Thomas Charles Edwards of the University of Oxford, who's going to talk to us about Bretha Comaithchesa and early Irish farming.
Fergus has been the first and only general editor of the Early Irish Law series published by the Institute. He has also been a major contributor to that series, and his Early Irish Farming has been an outstanding volume in the series, of interest far outside the dedicated band of students of Early Irish Law. We may think we're important, as it were, naturally enough, because here we are. But there are others outside us, as it were, for whom early Irish farming is a great text. It's true, moreover, that the evidence on which the early Irish farming depends ranges much wider than the laws themselves. This is true of texts, but something that gives the book its special character is Fergus's interest in biology and the link that his scientific interests have made with archaeology. Early Irish farming does not just deploy textual evidence. Archaeology is also crucial, guided by science. This last element in Fergus's scholarly armoury was already evident as long ago as 1976, when he published an article in Celtica 11 entitled The Old Irish Tree List. The main text of this list forms part of the law tract Bretha Comaithchesa, Judgments on Neighbourhood, on which I've been working for many years, too many years, for the Early Irish Law series. Fergus and I were fortunate enough to take part in a seminar on Bretha Comaithchesa given by D.A. Binchy here in the Institute in the academic year 1968 to 69. So you see how long some of us have been at it. The handout contains first a brief outline of the contents of early Irish farming, and second, a more detailed analysis of Bretha Comaithchesa with indications in bold of the relevant sections of early Irish farming. Now this, of course, was done for my good, so that I had an instant guide to which bits of early Irish farming I should be attending to at regular intervals. But it also shows the connection between early Irish farming and that particular text. In addition to legal texts, archaeology and biological science, a further strand in Fergus's early Irish farming is the critique of the conventional translation. A good example is canyen, generally translated leek, but Fergus gives good evidence to show that it was a particular type of onion. Another example is his discussion of bunkhor, almost universally translated green. Even when, as in that case, in the case of bunkhor, the conventional translation is not wholly wrong, its limitations are clearly exposed. One presumes that a revised dictionary of the Irish language will draw heavily on early Irish farming. I should take one example of a term in Bretha Comaithchesa that is given detailed treatment in early Irish farming, namely the term bunkhor. This is an uncommon term, attested once in paragraph 21 of Bretha Comaithchesa and also in a commentary in Rawlinson B 487, derived from that paragraph 21. Effectively, therefore, only a single attestation. However, it appears once also in Cormac's glossary, where it refers again to fencing. It is related to another compound of chor, bunkhor, which is attested in Irish as a place name, but is cognate with Welsh bunkhor, attested both as a place name and as a common noun. And here Fergus's discussion of the nocht aile, the bare fence, is of interest also to students of Welsh law. And the Welsh laws in their turn, as I shall suggest, may have something to contribute to the history of the Irish term bunkhor. On page 4 of the handout, you will find Fergus's diagram of the nocht aile, described in detail in Bretha Comaithchesa, paragraph 21, and on page 3 of the handout, the main text and draft translation of that paragraph, and also one of the relevant Welsh texts. The nocht aile, bare fence, was required to have 3 bands of pliable rods woven along a line of stakes. The commentary in Rawlinson B 487 adds one significant point to the account of the main text. There should be a space between the top bunkhor and the middle one, and likewise between the middle bunkhor and the lowest. Both make it clear, both the main text and the commentary make it clear that the stakes projected above the wattling fenderwyn. In combination, this information is enough to show that a bunkhor was a band of wattling, and the requirement for 3 such bands can be compared with a description of how a Welsh barn had to be constructed after the 1st of November in order to prevent animals from entering. Before then, it was open to allow the wind to enter, but after the 1st of November, the concern was to prevent animals from entering, and the function of the construction was thus much the same as that of the Irish nocht aile, namely control of animal movement. So on handout page 3, you have a brief bit from Latin redaction D, which may be translated, after the 1st of November, unless a barn be shut up and the wall is interwoven with 3 bunghori, even if an animal gets in and does damage inside, there shall be no compulsion to compensate. This Welsh comparison makes it likely, I think, that bunkhor, with which bunkhor is cognate, and it's not only cognate, but as it was clear from the early Irish annals treatment of the Welsh places called bunkhor, that the two were understood to be equivalent, so that the bunkhor is used for bunkhor quite naturally. So it's not just a philological fact, it's a current fact in the early Irish period that they know that these two are the same. Now, this Welsh comparison makes it likely that bunkhor, in which bunkhor is cognate, should be considered together with bunkhor in paragraph 21's description of the Nochtalie. These words are compounds, obviously, in the first case of Irish ben, Welsh ban, summit, and an element cor in a special sense of weaving or plaiting. And in the case of bunkhor, of bun, base, with the same second element. In both, the plating in question is evidently of the pliable rods. Ben and bun appear to be qualifiers, and cor the principal element of the compound. A helpful definition of the Welsh word bunkhor was given in 1730 by William Wotton and Moses Williams in their Leges Wadicae as, and this is on your handout, flexible rods, vergae plexides, thicker than the other twigs which bind a fence together at the top. They note that the word was well known in Breconshire in their day, namely roughly around 1700, and add, coming to the closer to the legal text, and this is the bit sapimenta ariarum, the enclosing walls of the spaces in which wheat once reaped used to be kept were strengthened by such rods in three places, above, in the middle, and below. It may be noted that this goes beyond the definition they've just given in one important respect. The definition understood bunkhor to be the interwoven strengthening rod at the top, but here we have such rods in three places, at the top, in the middle, and at the bottom. The reason partly for the rod at the top definition was presumably etymology, ban, summit. But that was in conjunction with surviving uses of the term in different Welsh districts, whereas I think the rod in three places explanation reflected the legal texts. If we add the evidence of the Irish bunkhor to this Welsh material, a possible answer may emerge. Bunkhor, the term used here in Bretha Comaithchesa, paragraph 21, for any band of interwoven rods, was perhaps in origin the word for the lowest of the three bands, whereas bunkhor, surviving as a place name, stood for the topmost band. The Welsh term bunkhor has also shifted in meaning to refer to the three strengthening rods, as in the example above, not just to the uppermost of the three. So what remains is a difference between the Irish and Welsh evidence, namely between bunkhor as a strengthening rod alongside lesser twigs and bunkhor as a band of wattling. The entry in Thomas Richards's Dictionary of 1753, which adds a bit of extra material about the distribution of the term in southeast Wales, also suggests that the idea of it as a strengthening rod had to do with the construction of a thorn hedge, which is a practice later than the period under discussion and much later than the period of Bretha Comaithchesa. So it's likely that the concept of the bunkhor in Bretha Comaithchesa gives the original sense, but I think bunkhor needs to be brought in to amplify the account. These words may also give a clue to the development of the word kora or kore, stone wall, as in paragraphs 5 and 20 of Bretha Comaithchesa, which is cognate with Welsh cored a weir. And what's more, the Irish term core, as Fergus pointed out, was also used for weir. When one adds the further detail, also pointed out by Fergus in early Irish farming, that fish weirs might be constructed from wattled fences or from stone walls, or a mixture of the two, the connection becomes pretty clear. If the ancestral corets from which cora is formed was created from cor in the special sense of a twist or turn, it is likely to have been originally used for the type of weir consisting of an interwoven fence, but was then extended in Irish to include a stone weir and finally a stone wall on land. Here, however, I must admit taking a different view of the history of the word from that espoused by Fergus in early Irish farming, page 287, where he maintains, and of course he may well be right, that stone wall was the basic meaning. But to me that seems slightly less likely in the face of Welsh cored, a weir. Now, the second part of this paper is a preliminary attempt to get to grips with one central feature of Comaithchesa, one that is presented in the two opening paragraphs of the tract. Those paragraphs begin along the lines followed by the early Irish grammarians with the bunedd, origin, and inye, essence of Comaithchesa. Also, in the fashion of the grammarians, it employs etymology as a tool to uncover this essence. And moreover, it is a double etymology, emulating the etymology of disciplina given by Isidore at the beginning of his Etymologia. I translate judgments on neighbourhood here. Why is neighbourhood so called? There is the same custom in it, for the custom by which each man exacts from his fellow fines and penalties is equally good. Alternatively, it is neighbourhood because a noble receives them, namely the fines and the penalties, in the same way as a commoner, and the ecclesiastical superior as a mere cleric. Now, even though part of the function of this passage is to exhibit learning, and so place this particular text and its author on an equal footing with the Latin scholar, it also succeeds in explaining at the outset one crucial aspect of Comaithchesa. Within limits, status makes no difference. The fine exacted by a noble would be no greater, other things being equal, than the fine exacted by the commoner. There are, of course, limits. Both the afech, the commoner, and the noble, the are, are free men. The slave and the whither and the bothach have no standing in Comaithchesa, apparently. As is notorious, early Irish society was characterised by numerous divisions of status. So the most detailed account in Cuith Govlach begins by aligning the ranks of Irish free lay society with the 7 grades of the church, but it then admits that if it be according to native Irish law, it is in greater detail that these 7 grades are distinguished. And it ends up with no less than 15 distinct named ranks. And as We all remember some Irish lawyers claimed that their own profession was responsible for this extensive hierarchy of status. So the original introduction to the Seanchas Mór, of great tradition, even goes so far as to claim that the world was in a state of equality until the Seanchas Mór arrived. Bretha Comaithchesa was indeed a tract belonging to the Seanchas Mór, so that it is all the more significant that in its domain, equality, at least for freemen, prevailed. Nor was this equality an idea peculiar to that tract, for it is implied by the very term coimhcheas, and that term was in general use throughout the Irish legal tradition. It is not just used in the Seanchas Mór, but also in the Bretha Neamh from Munster. The significance of this equality of status in coimhcheas is only reinforced by comparison with another area of law in which equality also prevailed, namely, according to Bretha Comaithchesa, in coin law and in, I quote, in the books of the church. Whereas, that tract carries on, it is in Féinechas that unequal dire has been established for the lay grades in the assessments of bloodlines. The contrast between coin, where status is not dominant, and Féinechas, where it is, only makes the law of coimhcheas, which belongs to Féinechas and yet is deliberately detached from status, all the more special. Coimhcheas is, of course, an abstract from coimhatech. These two terms are most extensively attested in legal texts, but they were not confined to the law, as is shown by the ironic remark made in the death tale of the Leinster hero Moelodhran. Ivail says, were neighbours, coimhatech, to Moelodhran, and yet his neighbourhood, his coimhcheas, was bad for them. And the point of this, as we shall see, is that coimhcheas was normally assumed to be beneficial for participating neighbours. The legal home of Athech, from which coimhatech was formed, is in the law of base clanship. Namely, the clanship that obtained between a noble lord on one side and a commoner on the other. And from that, Athech itself became a term of status, commoner. Yet once we shift over from Athech to coimhatech, the concern with status is left behind, since all alike are commoners. Whether they are nobles or themselves originally commoners, heads of churches, or the lowest grade of dependent clerics or monks, bunkhor, they have all descended to the status of an athech, for all pay the fines of neighbourhood. Thus, a common, lowly equality is at the essence of neighbourhood. The origin, the bunkhor of neighbourhood, was, according to Bretha Comaithchesa, partitioning of the inheritance. A query: from what does neighbourhood grow? From plurality of heirs. How is that? They first divide their shares and their holdings, and each of them fences against the other, and each of them grants a precinct to the other. On the one hand, this origin may make it easier to understand why status did not enter into the law of coimhcheas as it did into almost all other branches of Irish law. Brothers and cousins might be expected not to be far apart in status. Yet, the way the opening paragraph of Bretha Comaithchesa combined together as neighbours, coimhatech, noble and commoner, the head of a church with the lowest grade in that church, sits uneasily with an origin in sharing the inheritance. Other evidence only makes the problem more emphatic. One early text related to Bretha Comaithchesa confirms the importance of sharing an inheritance, and so too, up to a point, does paragraph 27 of Bretha Comaithchesa itself, which is to do with the absentee, the eshat. And where there are two competent co-heirs next to an absentee, what is done about the absentee? They distrain on him so that he may fence. And if he has no adequate farming equipment, distraint is taken on his close kindred, so that they may fence on his behalf, or so that they may alienate the pasture to the end of a year. If it be alienation of the pasture that the kindred grant, each of the two co-heirs makes a full fence, and they bring equal stock onto it, and each then gives a forepledge to the other in respect of it. There are three men involved here. Two are co-heirs, and thus presumably close kinsmen. The third is different, for the two co-heirs distrain on his close kindred, which can thus hardly be their own close kindred. Even for the two heirs, Comaithchesa is not an automatic consequence of their kinship. They must fence, and they must give forepledges to each other. In other words, the group of neighbours is established by deliberate act, a contract, even when those involved are kinsmen. And that helps to explain the situation that obtained before the absentee revealed his inadequacy as a farmer. The two co-heirs were neighbours on either side of the absentee, so the two of them, as well as being kinsman neighbours to each other, were non-close kinsmen, anyway, and neighbours to the absentee. Comaithchesa's neighbourhood was therefore a special legal regime in which the participants were often kinsmen, but not always, and it was established by contract. Once established, the legal regime created a special group of neighbours who had entered into this contractual relationship with each other. This contract of neighbourhood was privileged in that, like the contract of joint ploughing and the promise by a lord of a fief to his client, it was valid even if made in a state of drunkenness. So far as neighbourhood and joint ploughing were concerned, this can be explained on the grounds that the contracting parties were at least often kinsmen as well as actual neighbours, and so the particular contract was embedded in a long-term collaboration. The contract of neighbourhood is valid even when made in a drunken state, so we are told, because everyone is entitled to it from his fellow. Contracts of neighbourhood and joint ploughing were also privileged in the context of marriage between equals, both of whom contributed property towards the household and the farm. A spouse in such a union could make a contract of neighbourhood and joint ploughing without the explicit consent of the partner, because these contracts benefit their common resources. Apparently they are contracts into which any sensible farmer will enter with little fear of being the victim of exploitation. Similarly, contracts of neighbourhood and joint ploughing can be entered into by the person called the son of a living father, someone whose normal contractual capacity was severely limited. And finally, whereas our standard full-dress contract required the intervention of a surety, and the decisive act was made by the surety simultaneously holding the hand of each contracting party in one of his hands, the contract of neighbourhood seems only to have required a verbal agreement and the giving of forepledges. What one may call the tone of Comaithchesa is therefore collaborative rather than competitive, and hence the irony of the remark about the Cofaches of Moelodhran and Ival. Yet, all of this does not mean that Cofaches was a relationship between equals, only that it was a relationship constructed as if it were between equals. For this we have the testimony, as we've seen, of the opening paragraph of Bretha Comaithchesa. Also, even when the participants were kinsmen, that did not ensure actual equality of status. A standard problem in inheritance is what to do with sons who have reached adulthood but have not yet inherited land. In general, Irish law emphasised the subjection of sons of living fathers, but it did not preclude independent farming, as we have just seen. It is likely that one answer to this problem was for senior kinsmen to grant land as a fief of base clientship to a young relative. This solved several problems, provided land for young kinsmen to begin independent farming. It ensured that the land in question had the benefit of the labour of a young man, and it reinforced bonds of loyalty to kin. Such a custom, however, would enable the senior kinsman to begin at least to acquire noble status. And from another source we know that contracts of clientship between kinsmen were favoured. Not all participants in a group of neighbours were kinsmen, and, as we've seen, even when they were, they might be of very different status. Equality was not a given in Cofaches. It was something deliberately created. In one part of Bretha Comaithchesa, status matters a great deal, but the status is not of men, but of trees. An article by Fergus on the early Irish tree list and his early Irish farming has set out the details of the scheme by which trees, together with some bushes, were divided into nobles of the wood, such as oak, hazel, holly, and apple, commoners of the wood, such as alder, willow, and rowan, lower classes of the wood, such as blackthorn, elder, and arbutus, and finally, trailing ignominiously behind, mere bushes of the wood. This scheme is also found in the Poemon neighbourhood edited by Binchy in Celtica 9. And the division into ranks goes along with the differences in the compensations to be paid for injuring trees. Most severe is cutting the trunk of a noble tree, then cutting a principal branch, and finally cutting other branches. Apart from the very particular society of trees, however, social rank is kept out of Bretha Comaithchesa. It is unfortunately not obvious why this is so, and the text certainly does not offer an explanation. I only have a preliminary thought, which derives from a characteristic of the text, namely that it is overwhelmingly concerned with livestock, not arable farming. And indeed, on page 1 of the handout, you'll notice how livestock farming plays a major part in Fergus's early Irish farming. Ploughing is only mentioned in Bretha Comaithchesa in one paragraph, even though cooperation in ploughing was undoubtedly a general practice. Also, the standard relationship between a lord and a client was initiated by grant of livestock rather than of arable. I should add first that farming was assumed by lawyers to be mixed, and secondly that they distinguished between what we would call the standard factors of production, land, capital and labour, capital being largely in the form of livestock. Nobles then were nobles because they had a lot of capital, which they granted out to clients. And this capital continued to be owned by the lords until they died. The implication, therefore, is that nobles owned most of the livestock, but clans were in possession of most of the livestock. Livestock farming was mainly done by commoners with livestock owned by lords. Now, this is by no means a complete explanation, but it does provide a context in which it is less surprising that status distinctions were kept out of the law of neighbourhood. It may also explain why, in the law of theft, there is so much interest in compensating the person from whose land something is stolen, as well as the owner of the thing stolen. For livestock, that would often mean the client as well as the lord. It may also help to explain a feature of Bretha Comaithchesa. It generally adheres to a distinction between two kinds of penalty for trespass. One is the smacht, paid when animals have trespassed across a fence. The other is the cathig, paid when trespass occurred as the result of a human fault, such as neglect by a herdsman, and also when it was a case of a dunne cathig, such as damaging a neighbour's tree. The human fault would normally lie with the client, whereas if livestock trespassed without human fault, one might argue that the lord, the owner, rather than the client, the possessor, should be liable. The law of Comaithchesa avoids such problems. The agreement and the 4 pledges to guarantee it were a matter for the neighbours, not for the owner of the livestock, who might, of course, live at a distance. It still remains, however, a matter of great interest, and I don't think the problem has been totally solved, that in a society so divided by status, the principal day-to-day activity, namely farming, should consciously keep status at arm's length. Thank you very much.